Welcome to part 8 of my free YouTube course about franchise law in Ontario. As we continue learning about Ontario's Arthur Wishart Act, otherwise known as the Franchise Disclosure Act, in this chapter you'll learn about a concept known as joint and several liability. This concept is found at Section 8 of the AWA, and this section of the legislation is divided into 3 subsections. However, before we get into what Section 8 says, let's talk about the basic idea that we're working with. Joint and several liability is a legal concept that comes into play when 2 or more people are responsible for the same harm or debt. In simple terms, it means that each person involved can be held responsible for the entire amount of the damage or debt, not just their share. If you're a plaintiff, which is the person who was harmed or who is owed money, this rule gives you a better chance of getting paid because you can go after whichever defendant has the money, even if that person was only partly to blame. For example, imagine 3 contractors did a poor job building a house, and the total damage is $300,000, and let's say that a judge finds all 3 contractors jointly and severally liable. In such a situation, even if one was only 10% responsible, the homeowner can demand the full $300,000 from that person. This rule is used to protect people who suffer harm so they don't get stuck without compensation just because one of the wrongdoers is broke or can't be found. But from the perspective of the defendants, it can feel unfair because one person might end up paying way more than their fair share just because they happen to have deeper pockets. This concept often appears in tort law, like personal injury cases, contract disputes, and some types of business partnerships. For the purposes of this video, we'll talk about how Ontario's Arthur Wishart Act makes certain groups of people jointly and severally liable in the context of a franchise deal. You can see subsection 1 of section 8 on the screen now. You can pause the video here if you want to read it. I'm going to provide a plain language explanation of each subsection instead of just reading the law to you. This subsection says that if more than one person is responsible for breaching the duty of fair dealing under a franchise agreement, they can all be held legally responsible for the full amount of the damages, together or individually. This applies whether a court finds them liable or whether they admit they were at fault. To put it simply, if a franchisor and some of its directors or related companies breach their duty to treat the franchisee fairly, and the franchisee sues them under subsection 2 of section 3 of the AWA, then the franchisee doesn't need to figure out which one of them caused what part of the damage. The law allows the franchisee to recover the full amount from any one of them. Whoever ends up paying can try to recover money from the others later, but that's not the franchisee's problem. This makes it easier for the harmed party, the franchisee, to get compensated because they don't have to chase down each person involved and prove exactly how much each one is responsible for. Instead, the law treats them all as equally on the hook until the debt or damages are paid. Moving on to subsection 2 of section 8, this subsection says that if a franchisor or any of the franchisor's associates break the rules under section 4 of the Arthur Wishart Act, and a franchisee sues them for it, they can all be held fully responsible for the damages, either together or individually. This applies whether a court finds them liable or if they admit they were at fault. Section 4 deals with disclosure obligations. So, if the franchisor or one of their associates fails to give the required disclosure document, gives false or misleading information, or otherwise breaks any rule in that section, the franchisee can sue for damages. And under subsection 2 of section 8, it doesn't matter who made the mistake, any one of them can be required to pay the full amount of the damages. This rule protects the franchisee by making sure they don't have to go after each person involved separately or prove who exactly caused what part of the harm. Instead, the law lets the franchisee collect the full amount from anyone who is legally responsible. After that, the person who paid can try to get money back from the others. But from the franchisee's point of view, it's about making recovery easier and more certain. Moving on to subsection 3 of section 8, this subsection says that if any of the people listed in subsection 1 of section 7 are found responsible or admit responsibility for misleading information in a disclosure document or for failing to meet the disclosure requirements in section 5, then any one of them can be held fully liable for all of the damages. If you need a refresher, feel free to go back to parts 5 and 7 of this course for a deeper dive into how those sections work. You might remember that the list in subsection 1 of section 7 includes the franchisor, the franchisor's agent, broker, associate, and anyone who signed the disclosure document or statement of material change. So if, for example, a disclosure document contains false or misleading information and the franchisee suffers a financial loss, the franchisee can sue all of those people or just one of them and get the full amount of damages from whichever one has the ability to pay. Congratulations, you've completed part 8 of this course about franchise law in Ontario. In the next video, we'll group together sections 9 to 16 because they are fairly straightforward and not complex. Also, many of the remaining sections have been repealed, which means they are no longer part of the law. If you've made it this far in the course, then you should be very proud of your knowledge of this area of law, which is probably sharper than many lawyers in Ontario. Don't forget to subscribe. I'm Ryan Keeney, and thanks for watching. I'll see you in the next video.